So imagine you live in a state where the government out of nowhere passes a law banning an entire class of firearms, not allowing you to purchase them or possess them, maybe things like SBRs. And in response, you challenge that law and you tell the judge this is a violation of the Second Amendment and the Constitution, and it must be struck down immediately. And instead of defending the law, the state that you live in comes in and says to the court, we're not ready to argue that issue yet or defend our law. We don't want to talk about whether it's constitutional. Instead, we just want to delay this case. Now, that's exactly what is happening right now in a major federal lawsuit challenging a state ban on short-barreled rifles. And now the court has stepped in and made a move that tells us a lot about where this case is currently heading and what's going to happen next. So let's break down what is happening in this critical SBR challenge. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply by subscribing. You can also click the like button. That just tells the algorithm that you appreciate this type of two-way content, and so it shares it with more people. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom. And within your membership, the company AOR is always trying to give you as much as possible. They've added things, even since I've joined, like civil liability coverage, red flag law coverage, 4 guaranteed attorneys for your self-defense case, hero clause, and a lot of other things as well. And they're always trying to expand upon those benefits. So if you're interested in that type of coverage, check them out using the links down below. And if you decide to sign up and you use my code ARMSCHOLAR, you can get $25 off of your sign-up fee. So if you've been following the channel for a while, you will know what this case is about that we're going to talk about. This is the Firearms Policy Coalition lawsuit that they filed against the state of New Jersey, challenging the state's outright ban on the purchase and possession of short-barreled rifles, also known as SBRs. So this lawsuit was filed after Congress reduced the federal NFA tax to $0 under the Big Beautiful bill. Again, that reduced the tax from $200 to $0, which is currently in effect. And since that change, essentially there have been a wave of coordinated legal challenges aimed at dismantling the remaining restrictions on suppressors, SBRs, and other NFA items. FPC's core argument in this case is very straightforward. Short-barreled rifles are arms protected by the Second Amendment. They argue they are in common use for lawful purposes and that there is no historical tradition of banning these items outright. So New Jersey's total ban and prohibition on these items violates the Constitution and also what the Supreme Court said in that 6-3 ruling in Bruin. Now, here's where things are currently escalating in this case. After FPC filed their initial complaint, they also moved forward and they filed a motion for summary judgment, essentially telling the court that this case can be decided as a matter of law. And New Jersey did not like that. They did not respond, to that motion for summary judgment with any, reply or any historical evidence or anything refuting what was made in the motion for summary judgment. Instead, the state of New Jersey is arguing that the motion is premature, that discovery has not yet occurred, and that the court should delay this case and should delay deciding that motion for summary judgment and essentially ruling on the merits immediately. Instead, the court should push this out, punt this issue, and not directly address the constitutional question just yet. That procedural maneuver is the newest development, and it's critical to understand where this case is currently going. New Jersey also recently filed the formal answer in this case, and essentially the state is asking the court to dismiss the challenge entirely. Also, they're saying, they want a motion to dismiss, and they kind of want that sooner rather than later. First, New Jersey claims that the plaintiffs don't even have the right to bring the case. They argue the plaintiffs lack standing and that the case is not yet ripe for review. So in other words, New Jersey says that no one has actually been harmed enough yet by this law, so the court should not hear this case at all. Second, New Jersey claims absolute and qualified immunity. They argue that state officials cannot be sued for enforcing these types of laws. This is another kind of routine defense, but again, immunity does not apply when officials are enforcing unconstitutional statutes and laws, and so this lawsuit should be allowed to move forward. Now, their third argument that New Jersey makes is essentially that the SBR ban does not violate the Second Amendment because they claim it is consistent with the nation's historical tradition of firearms regulations. So in other words, they argue that even if SBRs are in fact arms, they can still be banned outright because governments have historically regulated what they believe are dangerous weapons. But here's the problem for New Jersey in this case. Under Bruin, the burden is on the government to prove a historical analog, and there's actually no founding era tradition of banning items outright, these categorical bans. In fact, in Heller, they talked about categorical bans on arms being impermissible, but also there is no type of ban on, shorter rifles or shorter firearms. There is no categorical ban that they can point to. There is no, SBR equivalent ban in 1791. There is no SBR ban in 1868, and the NFA itself did not even exist until 1934. So that is a huge constitutional gap that New Jersey has to overcome in this case. Now, here's where things are currently developing in this issue. Following a conference on March 31st, the court issued an order that directly affects both sides. The court administratively terminated the plaintiff's motion for summary judgment. So what that means is that the motions are not necessarily denied yet, but they are taken off the table for now. And importantly, the court made clear that the plaintiffs can still refile these motions at the appropriate time after discovery. So in essence, the district court bought New Jersey's argument that the court needs to delay this case for now and allow this to further develop with additional evidence. The court is effectively agreeing, at least for now, with New Jersey's argument that the case is not in the right procedural posture for this final ruling on the merits. The court is essentially saying we want more arguments and more evidence. But this is important. This is not yet a win for New Jersey on the merits. The court did not say that the ban is constitutional. The court did not reject FBC's arguments. All the court said is not yet, come back later after we do discovery. New Jersey's main argument was that the discovery has not taken place yet, and they said that they need additional time before the court can decide this issue and before they want to present their arguments to the court. So in short, instead of jumping straight into defending the ban under the Second Amendment and Bruin's historical test, the state of New Jersey did a procedural move. They did not want to address the merits. Instead, they tried to slow this case down, slow down the timeline to benefit them so they don't actually have to defend this law just yet. And at least for now, that strategy worked and the court agreed with New Jersey. The court effectively paused the motion for summary judgment, so the case will now move forward to the next procedural steps of discovery and further development of the record before the court revisits the actual constitutional question. But eventually, the court will have to decide, does New Jersey's SBR ban survive under Bruin? Is there historical support for banning SBRs? Or does this law collapse like so many others after Bruin? And if FBC wins here, this opens the door for striking down other state bans on NFA items like SBRs and suppressors, including in states like California, New York, Illinois, and others. So that's where things currently stand in this critical FBC versus Platkin case challenging a state's SBR ban. And again, this kind of developed after the $0 tax change. New Jersey has successfully kind of slowed this case down, at least for now, but eventually they are going to have to face the constitutional question and try to defend this law under Bruin and the Second Amendment. So as this develops more, as we get more information, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm, just tells the algorithm that you appreciate this type of content, and so it shares it with more people. But as always, thank you so much for all of your support, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.